Welcome back. I am Jayashree from Institute of Sai. We will continue with Order 5, Rule 22. We have done till 21. In this session, we will be doing from Rule 22. Okay. Rule 22. Service within presidency towns of summons issued by courts outside. Where a summons issued by any court outside beyond the limits of towns of Calcutta, Madras and Bombay is to be served within any such limits, it shall be sent to the court of small causes within whose jurisdiction it is to be served. Why we call it as presidency towns? Because they were presidency towns during the British rule in India. Okay, so you had something called as provincial towns and presidency towns. Okay, so whichever were the capitals were known as presidency towns. So you have Calcutta, which is now Kolkata, Madras, which is now Chennai, and Bombay, which is now Mumbai. Okay, so these three are known as presidency towns. Sorry, these three are known as presidency towns, and any court which has to serve summons for to any defendant residing in these three presidency towns, it has to send the summons to the court of small causes, which in turn will serve the summons. Okay, to the defendant. But what is it? The procedure and the modes of service of summons, everything shall remain the same. Okay, the power of the court, all that shall remain the same. Then Rule 23, duty of court to which summons is sent. So what is the duty of the court to which summons is sent? Now we have already spoken about the jurisdictional court and the defendant residing in the jurisdiction of another court. So when the summons is sent from the jurisdictional court, that is where the suit is instituted, to the other court where the defendant resides, then what shall be the duty of that particular court which is serving the summons on the defendant? Okay, as soon as it receives the request and the summons from this particular jurisdictional court where the suit is instituted, it shall serve the summons on the defendant in the same manner as the original jurisdictional court would do. Okay, so it shall serve the summons on the defendant and give a report. Report, when I say, it is not a report or anything like that. It shall give appropriate information to the jurisdictional court saying that the summons has been served on the defendant by this particular mode on this date. All the details of service of summons shall be written and it shall be sent to the original jurisdictional court. Okay, when I say original jurisdictional court, I mean to say the court where the suit has been instituted. That is not the original jurisdiction. Everything is of original jurisdiction only. Okay, so the court to which a summons is sent under Rule 21 or 22 shall, upon receipt, proceed as if it has been issued by such court and shall then return the summons to the court of issue together with the record. All the details of the issue of summons shall be written there. Or if the court was unable to serve the summons on the defendant, then that also shall be written down in the record. Okay, and why it could not be served on the defendant, all these shall be written down. Then Rule 24, service on defendant in prison. If the defendant is in prison, see, we cannot say that everyone will be out in the world, right? So some defendant, he may be a defendant in the suit, may be in prison for some other reason, either a criminal case or maybe he is in civil prison. Anything may happen, right? So how to serve a summons on the person in prison? Where the defendant is confined to a prison, the summons shall be sent or delivered by post or by courier service or fax message or electronic mail or any other means. The mode of service will be the same as for all other service, whether it is within the inside the prison, whether the defendant is in prison or outside the prison, that doesn't matter. The mode of service shall be the same. Okay, but to whom shall it be given? It shall be given to the officer in charge of the prison for serving on the defendant. We cannot go inside directly and serve it on the defendant. Okay, I mean to say, when we say we, it cannot be, I mean the court officer or the RPAD or email or whatever it is, it has to be through the officer of the prison. Then Rule 25, service where defendant resides out of India and has no agent in India. Okay, where the defendant resides out of India and has no agent in India, empowered to accept service, the summons shall be addressed to the defendant at the place where he is residing and sent to him. Again, the mode of service will be the same, either by post or courier or email or fax message. Okay, if there is postal communication between such place and the place where the court is situate. So where there is a postal communication, where if I post a summons here, if it is going to reach some address which is given in Australia, say for example, then the summons shall be sent by post. Otherwise by nowadays the common one is email, right? Not even fax message. Email is very common nowadays. Okay. Provided that where any such defendant resides in Bangladesh or Pakistan, there are exceptions. Okay. So you just underline. You underline that provided that, so that when you look at the page, you will know that you have to read it. Okay. So underline the words provided that. Where any such defendant resides in Bangladesh or Pakistan, 2 countries. The summons together with a copy thereof may be sent for service on the defendant to any court in that country, not being the High Court. So it shall be the same district level court only. Okay. Having jurisdiction in the place where the defendant resides. So here no post can be sent. Bangladesh, Pakistan. Okay. Other than that, any other country we can send by post, but not here. Okay. For this, what has to be sent? The summons has to be sent from a court in India, whichever is the court, jurisdictional court in India, to a district court or whatever, the same level court in Pakistan or Bangladesh, wherever it has to be served. Okay. And then the court shall, that particular court in Pakistan or Bangladesh shall serve the summons on the defendant there. Provided further that where any such defendant is a public officer in Bangladesh or Pakistan, not belonging to the Bangladesh or, as the case may be, Pakistan military, naval or air forces. So the defendant should not be a member of the armed forces of Bangladesh or Pakistan. Hope you are able to understand that. It's very simple. The defendant should not be a member of the armed forces of either Bangladesh or Pakistan. Okay, he should not be a member of the armed forces. Or is a servant of a railway company or local authority in that country. The summons together with a copy thereof may be sent for service on the defendant to such officer or authority in that country as the central government by notification specify in this behalf. Okay, if the person is a public officer in Bangladesh or Pakistan, he is a public officer. Public officer means any government department, am I right? So if he is a public officer either in Bangladesh or Pakistan, but not a member of armed forces. Okay. So then how will this summons be sent? Summons will be sent to the officer in charge of that particular department in Pakistan or Bangladesh. Okay. And which officer, how will we know who is the officer there, the authorized officer? By looking at the official gazette. Then next we go to the next rule, rules 26. Service in foreign country through political agent or court. Where it can be. Where can it be done? Okay, service of summons through political agent or court. In exercise of any foreign jurisdiction vested in central government, a political agent has been appointed or a court has been established or continued with power to serve a summons issued by a court under this code in any foreign territory in which the defendant actually and voluntarily resides, carries on business or personally works for gain. In case there is a court which is already in place or which has been established in that particular foreign country only for service of summons, then summons can be served by such a court. Okay. Or the second option, the central government has by notification in the official gazette declared in respect of any court situate in such territory and not established or continued in the exercise of any such jurisdiction as aforesaid, but that service by such court of any summons issued by the court shall be deemed to be valid service. That is like, from one state to another, when we send the summons from, say, for example, from Karnataka to Kerala. Okay, the Kerala court will serve the summons on the defendant. Okay, so same way, but what is the difference here? This is a foreign country. Okay, and India has not established any court, or no one else has established any court, or it has not been established or continued. No court has been established or continued for the purpose of service of summons only. Okay, but in the second case, B, what we are talking about is, it's a proper foreign court. Okay, then such court shall serve the summons on the defendant. The summons may be sent by such political agent or court by post or otherwise, or if so directed by central government through the ministry of that government dealing with foreign affairs, or in such other manner as may be specified by the central government for the purpose of being served upon the defendant. If the political agent or court returns the summons with the endorsement purporting to have been made by such political agent or judge or other officer of the court, to the effect that summons has been served on the defendant in the manner hereinbefore directed, such endorsement shall be deemed to be evidence of service. Okay, so political agent, when we say political agent, it is the embassy, am I right? It is the embassy or the Ministry of Foreign Affairs, the External Affairs. Okay, the External Affairs Ministry, there is an embassy which has been set up in such a country. So summons can be served either through court or through such political agent. Okay, and the record that they send back saying that the summons has been served on the defendant is good evidence for service of summons on the defendant. Okay, later the defendant cannot say, no, I was not served any summons at all. I didn't know about the case. Clear? The record of the external affairs or the foreign court is sufficient evidence. Next we go to Rule 26A. Summons to be sent to officers of foreign country, where the central government has by notification in the official gazette declared in respect of any foreign territory, so that summons shall be served on defendants actually and voluntarily residing or carrying on business or personally working for gain in that foreign country, may be sent to an officer of the government of the foreign territory specified by the central government. Please underline, government of the foreign territory specified by the central government. So it cannot be any officer. Okay, it should be the particular officer of the government of that particular foreign country which our central government has specified. So only to such officer it can be given. Okay, the summons may be sent to such officer through the Ministry of Government of India dealing with foreign affairs, Ministry of External Affairs, or in such other manner as may be specified by the central government. So basically what you have to remember, when summons has to be sent to be a foreign country, it should be to the officer whom our central government has notified as the authorized officer. Understand? Then Rule 27. Service on civil public officer or on servant of railway company or local authority. See, they are all deemed to be public public officers. Am I right? So how will summons be served on them? Where the defendant is a public officer not belonging to Indian military. Again, same like how we read in Pakistan or Bangladesh, same thing applies here. Okay, where the defendant is a public officer but he does not belong to the armed forces, or is the servant of a railway company. He is a public officer or he is a railway servant. Okay, railway authority, servant of the railway authority or railway company or local authority. When we say local authority, it is the municipal corporation. Am I right? So where he is a public officer or a servant of railway company or local authority, The court may, if it appears to it that the summons may be most conveniently so served, send it for service on the defendant to the head of the office in which he is employed, together with a copy to be retained by the defendant. So he should not be a member of the armed forces of India, okay, but if he is a public officer or a servant of railway company or local authority, summons can be served by the court to the head office. Head of the office. Head of the office means what? See, if he is there in the head office, then it can be sent to the head office, okay. But if he is not there in the head office and it cannot be sent to the head of the office in head office, it shall be sent to any branch that he is working, but it should be to the head of the department. See, for example, railway officers are there in all the states, am I right? So when we say it cannot be sent to the Indian Railways main headquarters, it should be sent to the branch office, and in that branch office also it should be sent to the head who is heading the particular railway branch. Clear? So Southern Railways means in the southern this thing, like that, So it should be sent to the head of the office. Any other department you take up, whoever is the head of the office where the defendant is working, to that particular head of office, the summons has to be given along with a copy. One copy shall be for the defendant. We have already seen that. So I don't think we need to tell it again. Then Rule 28. Service on soldiers, sailors or airmen. See, this thing is given separately, right? For armed forces. Where the defendant is a soldier, sailor or airman, the court shall send the summons for service to his commanding officer, together with a copy to be retained by the defendant. So, the summons shall be just like how it shall be sent to the head of the office when it comes to public officer or railway company or anything. Same way, if the person is a member of the armed forces, the summons along with a copy of the petition or plaint rather shall be sent to the commanding officer where the defendant is a soldier or a sailor or airman. Rule 29. Duty of person to whom summons is delivered or sent for service. So what is the duty? When a summons is delivered or sent to a person for service under Rule 24, Rule 27 or Rule 28. So what? Public officer, foreign authority, on armed forces, members of armed forces. Such person shall be bound to serve it if possible and to return it under his signature with the written acknowledgement of the defendant, and such signature shall be deemed to be evidence of service. Same way, whatever we saw with the foreign authorities, the Ministry of External Affairs, same procedure has to be followed here too. The head of the office, or when it comes to the armed persons or public officer or whoever it is, whoever is the head, the commanding officer or head of the office or the foreign court or the Ministry of External Affairs, they have to give a report saying that we have served the summons, and it shall be under that authorized officer's signature and seal. That shall be taken to be sufficient service of summons on the defendant. Sub-rule 2. Where from any cause service is impossible. See, you should note the word impossible, okay? Just underline it there. Service is impossible. The summons shall be returned to the court with a full statement of such cause and of the steps taken to procure service, and such statement shall be deemed to be evidence of non-service. Say for example, when it is armed forces, probably the commanding officer is somewhere at the base. Probably. I have absolutely no idea. I am just giving you an idea. He is at the base and the soldier is somewhere high up near the border. So it is not possible to serve the summons. Then it shall be returned, stating the cause. If it is a public officer and he is on a long leave, so the head of the office is unable to serve it on the public officer, then also it shall be returned. Same way Ministry of External Affairs. Wherever the service is impossible, it is not that, okay, today he is not there, okay, let me try tomorrow. We've already seen that, right? So, where it is like that, where it is impossible to serve the summons, in such cases, they can give a writing saying that this is the situation, therefore we are unable to serve the summons. Okay, and that shall be sufficient proof for non-service of summons. Rule 30, substitution of letter for summons. Where there need not be a summons. See, you have something called privileged positions. Am I right? President of India, governor, all these people are all in a privileged position. So we cannot send a summons saying that, come on, you appear before me on so and so date at so and so time. We cannot do that, right? I mean, the court cannot do that, right? Therefore, letter can be given instead of summons. Okay, we will just go through it now. The court may, notwithstanding anything herein before contained. Why is it given there? Because in the previous rules when we were reading, it says that it is common for all. That's the understanding which is given to us. Am I right? Even the member of armed forces is not left out. They are not given any privilege. Right? So therefore, whatever, notwithstanding anything herein before mentioned, even though so much we have mentioned in the previous rules, this rule is different. That's the meaning which is given to it. Okay? Substitute for a summons a letter signed by the judge or such officer as he may appoint in this behalf, where the defendant is, in the opinion of the court, of a rank entitling him to such mark of consideration. Where the court feels that we cannot just like that send a summons to this person. It cannot be any ordinary person or anything. It has to have a constitutional privilege, right? Subrule 2. A letter substituted under Subrule 1 shall contain all the particulars required. Same as whatever is written in the summons, same shall be written down in the letter also. All the details about the case, date of appearance, time of appearance, everything should be there. Before whom the person should appear, everything, all the details will be there in that. Subrule 3. A letter so substituted may be sent to the defendant by post or special messenger selected by the court. Why special messenger? Because the person himself is a special person. Okay? A special person in the sense what? He is having certain privileges. Or in any other manner which the court thinks fit. And where the defendant has an agent empowered to accept the letter may be delivered or sent to such agent. So it can be either by way of post or special messenger. And again, it can be either directly on the defendant or any authorized agent. Okay. So this is as far as the privileged people are concerned. We will stop with this. We will continue with the next order, that is order 6 in the next session. Okay. Thank you.